Good morning, everyone. Welcome to our Standing Committee on Public Accounts. This is Tuesday, October 20th, and as with all of our meetings, I'll begin with our mandate and our statement of purpose and values. The Standing Committee on Public Accounts is charged with matters concerning the public accounts of the province, the annual report of the Auditor General, and fiscal management. The Standing Committee on Public Accounts is dedicated to improving public administration in partnership with the Auditor General. The committee examines the administration of government policy, not the merits of it. The committee strives to achieve consensus on its decisions whenever possible. Members take a nonpartisan approach to the work of this committee. So I'll call the meeting to order, and I'd just like to welcome everybody. We have Gordon McNeely, Sunny Gallant subbing in for Robbie Henderson, Corey Deagle, and Carla Bernard with us today. And I will ask for an adoption of the agenda. Carla Bernard, thank you. So with us today, we have the office, the Office of the Public Trustee, and they are with the Department of Justice and Public Safety. So we have Karen MacDonald, who's the Acting Deputy Minister, with us today. And we also have Clare Henderson, Director of Family Law and Court Services. They'll be providing us a briefing of the implementation of the Auditor General's 2017 recommendations for the Office of the Public Trustee. And they'll also be providing an update of the 2016 recommendations for the Maintenance Enforcement Program. So I'll turn it over to you, and perhaps what we can do is we can go through one first and then take any questions. So is it the Office of the Public Trustee that you'd like to begin with, or Maintenance Enforcement?
We wondered if we might be provided the opportunity to make a brief opening statement.
Absolutely, yes, thank you.
I can do that, and then I'm going to hand it over to Ms. Henderson. So the Department of Justice and Public Safety is responsible for the Maintenance Enforcement Office, the Office of the Public Guardian, Official Guardian, and the Public Trustee. So significant work has been done by the staff in these offices to implement the recommendations of the Auditor General, not only to reach the full compliance with the recommendations, but also to ensure that we're providing good public service to clients and the users of these systems. The Maintenance Enforcement Program is a free service that is provided to island families to assist with the collection and disbursement of support, both spousal support and child support. It is a neutral, order and agreement-based program that does not advocate for one party or the other, but it takes actions based on the order and the program policy manual. While the program is not a guarantee of collection, enforcement officers have the tools available to assist with the collection of that support. These tools, for example, include suspending a driver's license or intercepting a tax return. And Ms. Henderson's going to speak more about the specifics of how that program operates. So the Office of the Public Guardian, Public Trustee acts as a legal substitute decision maker for individuals who come under the care of the office. For the Public Guardian Office, this means a judge has found a person medically incapable of making personal care decisions. For the Public Trustee, it means that two doctors have certified that someone cannot manage his or her financial affairs, or a court has ordered the Public Trustee to be involved. Ms. Henderson will also provide further information about these programs. So I know that Ms. Henderson was here in February, and you heard a lot about the work that was undertaken by the Maintenance Enforcement Program in relation to the 2016 recommendations. Today you're going to hear an update from her on the status of those audit recommendations. And in addition, she will update you on the status of the implementation of the audits in the Public Guardian and Public Trustee Office. The updates she will provide represent really, I think, amazing work done by both she and her staff in both of those offices. And the implementation process undertaken in each of these offices has resulted in better service delivery for island families and for vulnerable islanders. And I can assure you that each of these offices has taken significant action to implement the recommendations of the Auditor General since the reports were released. Each recommendation, which Ms. Henderson will discuss this morning as now being complete, represents significant work undertaken over the past number of years by the staff and by our department. We are dedicated to providing exemplary service to islanders, and this is not merely the work of the past few months. So we do appreciate the work of the Auditor General and the recommendations, and we appreciate the opportunity to appear here today and provide further information on the status of our implementation. So as our subject matter expert, I'd like to hand things over to Clare Henderson.
Thank you. Go ahead, Claire. Thank you.
Thank you. And again, my name is Clare Henderson. I'm the Director of Family Law and Court Services with the Department of Justice and Public Safety. I happen to be responsible for each of the sections that were audited by the Auditor General. And I can advise you that both the Public Trustee Office and the Maintenance Enforcement Office, and in fact the Public Guardian Office, which was also subject to a value for money audit in 2018, which I'm happy to update you on as well if you would like, have spent thousands of hours on working on audit implementation and getting compliance with the recommendations of the Auditor General. And I'd like to point out that this work, the implementation work that we've done, is over and above the daily operational work that my staff do every day. The Maintenance Enforcement Office is an office of 7 staff. They have approximately 1,700 support files that are registered with the program. And as you may be aware, I heard somebody once say that the two things that are the most controversial, the most high conflict for people are children and money, and we deal with both. And so the daily work of my staff in the Maintenance Enforcement Office involves daily contact with some of the most high conflict individuals in the family law system. The Public Trustee and Public Guardian Office is also a staff of 7 people. The Public Trustee Office has about 300 clients. The Public Guardian Office has about 80. And for each of those individuals, they are tasked with making personal care and financial decisions. And I'd like you to take a moment and think about every financial decision that you make in a day. We are responsible for making those decisions for those clients. And the people who are our clients are some of the most vulnerable people on the island. They're under our care because a doctor has said that they are incapable of managing their own affairs. These are individuals who are dealing with significant challenges, including mental health disorders, brain injuries, and so the amount of contact that they have with our office is high. The Public Trustee Office is responsible for all of the financial decisions, not only the daily financial decisions, but ensuring that we are securing appropriate benefits for our clients, so many of whom would be eligible for CPP. But for example, that is often complex for the people who come under our care, because when someone has been declared incapable of managing their financial affairs, it is often after a period of mismanagement. And so when we take on a new client, we often have to do 10, 9, 7 years of back taxes and locate that information. And I say all of this because on top of the significant work that my dedicated and amazing staff has done over the past 3 years, they are providing amazing service to the vulnerable people that they represent in terms of substitute decision making. And I cannot tell you how pleased I am to sit here and tell you that we are going to be reporting 100% compliance with all recommendations for all audits for all sections. So 100% recommendation compliance with the Maintenance Enforcement Office, 100% compliance with the Public Trustee Office, and 100% compliance with the Public Guardian Office. And as Ms. MacDonald pointed out, you may recall I was here in February and we weren't at 100%. I cannot stress enough that this work was not done in the past 6 months. This work has been work that we have been doing for the past 3 years. And unlike horseshoes and hand grenades, almost doesn't count with the Auditor General. And fair enough. You may recall that last time when I was here in February, I said we were 2 weeks away from being complete when we had to report to the Auditor General. 2 weeks. That doesn't count. So we have completed a great deal of work, and I can tell you that there is no one that is more happy to be reporting that than my staff. And it is their work and their dedication and the support that we received from the Department of Finance, and because of our relationship with the Auditor General's office. And I do want to take the time to thank the Department of Finance, who provided significant support, and the auditor. I can tell you that the financial statement audits for the Public Trustee Office are extremely complex. As you can imagine, we have trust accounts, we have investments, we have any number of financial things that make our audit, I would suspect, one of the more complex audit that the office engages in. There was one point last year when they were engaging in our audit that there were 4 auditors in our office. We had them stacked in offices because I didn't have anywhere to put them. This was pre-COVID, thank goodness, because I don't know what we would have done with the 4 auditors. But they have done significant work to assist us and provide us support and recommendations in terms of how to make our office better. And I can also tell you with 100% confidence that the fact that we are 100% compliant doesn't mean that our office is going to stop striving to provide better public service, to provide better support to the people that we are dealing with. And I'm happy, depending on how you would like, to go through each audit recommendation individually. I'm in your hands as to how you'd like to hear the awesome news.
All right, well, first of all, what I'd like to say is thank you, Claire, because as we heard last time that you were in, this was a process that had been happening over 3 years. And when you see it in black and white, it is pretty, stark when you see 3 implemented, 9 not. And I think we all recognize that it does take time to implement. But the role of the Auditor General is not just to come in to audit, but she's coming in, or the Auditor General is coming in to identify what's written in legislation and what is being actually completed and where is the gap. So I'm happy to see, like, when the recommendations are implemented, that actually brings us up to what the legislation is saying that we should be at, then removes all that level of work that was being done to catch up to actually move forward. And it would alleviate some of the stresses and the resources in the office because that extra workload of catching up is no longer there. So then it's, going forward, keeping at that level, right, where it's in compliance. So I appreciate the work that your office has completed because fully recognize that there was a lot of challenges, a lot of people involved. So I'll ask the committee, how would you like to proceed? Would you like to just proceed into questions or section by section? So do maintenance enforcement first and that as an update to where we were, and then move on to public trustee? Or do you want to just ask questions over both of them? Gord? Does it matter?
Yeah, just whatever way you'd like to proceed is fine.
Okay, so we'll open it up to questions, and unless you have something else prepared, we'll open up to questions, and who would like to go first? No takers?
That all sounds great.
It does sound great. Carla?
I'm just wondering, as of February 2020, it was $10.4 million that was owed to maintenance enforcement, and I'm just wondering what that amount currently is now. I know there's like a funny, not funny, but like kind of a math equation. It's not all as black and white as that part would look. I'm just wondering what that number looks like right now.
We're at about the same presently. Again, like we spent some time discussing last time, unfortunately, the arrears balance with maintenance enforcement doesn't really tell a story, right? Particularly, I'm actually anticipating as a result of the pandemic that our arrears balance is going to go up significantly as people are moving back to this jurisdiction. Like we talked about last time, if we have somebody who moves home from out west or they move from Ontario and they've had a support order that's been registered with the other equivalent maintenance enforcement program, they bring any outstanding arrears with them. And so they start day one in our program with an arrears balance. And as you may recall from our discussion on the last occasion, that arrears balance represents less than 10% of the files in the program. We actually have the second highest compliance in the country for payment with support. And so while I acknowledge that, a $10 million number that's a large number, but it is extremely challenging to look at that number and judge the effectiveness of the program. The second issue is, as you can imagine, there are individuals who take significant action to evade being obligated to pay child support. Maintenance enforcement has many tools in our tool belt to try and collect funds, but we can only collect legal income sources. And so if somebody is being paid in cash under the table and they're not depositing that into a bank account, we have no way of, one, knowing about those funds, or two, intercepting those funds. And so we have done significant work over the past 3 years to maximize our effectiveness in being able to locate legal resources that we can then take action against. But, you know, if we also have, for example, individuals who leave the country rather than pay their support. And so, you know, we have, for example, implemented policies and procedures that, you know, if you have an arrears balance with our program, you are immediately subject to a federal interception, which means if you are receiving HST or an income tax return, we are going to intercept those funds and take those funds and apply them against your outstanding arrears balance. We also have implemented an income tax clinic program in partnership with the Canadian Revenue Agency, where when we are doing default hearings, or when we have individuals who are indicating they can't do particular things because they haven't filed their taxes, we have a volunteer who is present there that day, able to assist them with filing their taxes. And at default hearings, we make a judge aware of that, and a judge directs them to attend with the income tax clinic to get those taxes done. And so we have seen, despite the $1 million number, we have seen a significant improvement because of the availability, in particular, of that service, with our ability to intercept funds via income tax returns, because we're now not only saying you must do this, we're saying we have a very helpful free service that will do this for you.
Carla? I just have a couple of kind of random questions, and then a couple of questions related directly to some of the recommendations. I'm just wondering if your office gathers any data on who is on the receiving end, or the potential, the hopeful receiving end of receiving the maintenance enforcement payments. Does that tend to be more men or women?
So we, as part of a federal government initiative, provide anonymized data reporting to the federal government and Statistics Canada about basically it's a social data linkages reporting. And so we provide anonymized data to the federal government. And so we don't do that reporting ourselves. We do that via the national standard of StatsCan. And if you go to the Statistics Canada website through their really interesting CanSIM tables that I don't know that enough people spend time looking at, there's a great deal of data that's available about who is statistically receiving support and support eligibility and things like that.
Carla?
And I think one of the reasons that it was this falling under your department was so concerning for me, and I'm sure for many of us, was that, like you said, you are working with such a vulnerable population, whether it be the children, whether it be people who deemed not able to care for themselves, or people who live in high conflict situations, or people who tend to be high conflict for whatever reason. And then you said that, so there's 7 staff who've been working diligently on doing the day-to-day stuff, and then also implementing all of these recommendations, which I totally appreciate. So I'm wondering if you see this, you know, if you had a magic wand and you could have as many people kind of working away at the office, how many people do you feel it would take to be able to do, you know, all of the things, so that, because I know last time that you were in, and please correct me if my memory does not serve me right, but there was some talk about a little bit of inconsistency between things. So I'm just wondering how much of that is kind of a staffing issue. Do you have any sense of that?
So we were talking, in terms of the inconsistency, we were talking about some of the concerns that had been raised by the Auditor General previously. Right. So we actually have a very comprehensive policy manual that assists both the public and staff in terms of understanding some of the decisions that are made by the program. I also need to just point out that it's important to remember in this discussion that particularly the maintenance enforcement program is neutral. We do not represent the person who's receiving the support or the person who's paying it or the child. The maintenance enforcement program is a neutral order or agreement-based program. We don't advocate for one party or another. We merely administer and enforce the support obligations that are set out in the court order or the registered agreement. And so in terms of the staffing complement in the office, we engage in a kind of a planning process for staffing allocations. We have an additional position for the office that's going to be finance related that we're working on presently. But in terms of enforcement officers, I am confident that we are adequately staffed in terms of the volume of work that they are doing. Again, in terms of both the tools that are available to the enforcement officers for their work, I am confident that we are maximizing the enforcement that we are able to do under the legislation. And again, and I understand, but one of the things that can be challenging in terms of the maintenance enforcement program is remembering that enrollment in the maintenance enforcement program is not a guarantee of collection. It is the obligation of the person who is ordered or who has agreed to pay support to pay that support. And so our obligation through the program is to ensure that we are doing everything possible to collect that support if it is available. But again, it becomes complicated because I can only enforce against legal income sources. Or if, to give you an example, we often will have files where somebody moves from another jurisdiction, their previous order indicates that they're to be paying support at an amount based on the salary in the other jurisdiction. So let's say that Claire was working in Nunavut and she was making a fairly particular salary. Then I come to PEI and I am in a similar position, but my salary has been reduced by an amount. If I don't take steps or I come home and I don't work, if I don't take steps to change that order, which is based on my previous income, the maintenance enforcement file continues to accrue arrears on that balance. And sometimes we have files where the person who is paying the support is only paying a particular amount, and the recipient of the support is fine with that. Our file is accruing arrears at an alarming rate, and we are taking enforcement action on that basis. We can refer those individuals to a program that is also offered through my office called the Child Support Guidelines Office, saying we have a free service that can provide you information and assistance to go to court and have your order changed. But if they don't want to do that, we are a neutral order-based program, and we can't change the order that the judge made in the other jurisdiction. So we have to enforce and accrue arrears on a balance that we know is not necessarily accurate and the parties aren't concerned about. But I come here and my arrears balance is at $10 million because in some cases, people aren't taking steps to ensure that their order is current, right? So these are, as we discussed last time, maintenance enforcement is one of the most complex enforcement situations that you can run into because there's 2, sometimes 3 sides on a file, and we are neutral, and so we don't make decisions on the basis of what we think is in the best interest of the payor or the recipient or even the child. That is the obligation of the people who are the parties to the order or the agreement, and we can strongly suggest that people take steps to either that they may wish to consider varying an order, but ultimately that's the decision of the party who is subject to the order or agreement. I am legally obligated to take steps to enforce the order that is registered with the program unless the parties choose to withdraw that order.
Carla?
Thank you. So just quickly on that, so the Office of the Public Trustee would be different than the Maintenance Enforcement Program because it's not a neutral
Absolutely.
approach. Yeah.
So the Office of the Public Trustee is something called a legal substitute decision maker. And so that means that once somebody comes under the care of our office, We, for the purposes of making the decisions for the public trustee, that means the financial decisions. And much like with a lot of the law, this is subject to some corollaries and some contingent situations, but let's just focus on the easiest piece right now. If you were to be certified by 2 doctors as being incapable of managing your financial affairs, we are, for the purposes of making those decisions, you. So we are substituted, the public trustee is substituted for you in terms of the legal authority to make those decisions. And so once the public trustee office is certified to be involved, we make the decisions for the person. And because of the nature of the work, we often, in every instance, we try to involve the individual who comes under the care of our office in all of the decision making. But as you can imagine, individuals who are ordered under the care of the office generally have significant challenges and are with us because they are incapable of making those decisions. And so to ensure that we are respecting the dignity and autonomy of the individual clients, we actively try to involve them in the decision making. For some individuals, that means we provide them notice and we meet with them about the decisions that are being made. But for some we're not even able to do that because we, for example, would have clients who are in perhaps a vegetative state in a long-term care home. But the person at law is no longer able to make those decisions for themselves until the certificates are either set aside or they return to capacity. Because it's also important to understand that sometimes our office can be involved for a period of time and then our involvement can cease. So we do what we can and we take immediate action to try and protect the financial interests of clients. But ultimately, the public trustee is the decision maker. And when we are making decisions, that office consistently considers what the best financial and best interests of the client are. And it's not what would Clare do with that money and what decision would Clare make about that particular circumstance. The question is, what is in the best interest of the client? What decision do we need to make sure that they are financially protected? Because being involved with the public trustee office is not, I'm not great at making financial decisions and maybe Clare shouldn't have spent a whole bunch of money on Amazon buying dresses, right? Maybe that's not appropriate budgeting. There is a legal and mental incapacity to my ability to make decisions in my own interest, and it's putting me at risk, effectively.
Carla?
Appreciate that. That was actually going to be my next question is if they're involved kind of as much as they can be. I'll ask one more question and then I do have a couple more, but I'll let someone else ask. So we talked about, you were mentioning, back to maintenance enforcement, you were mentioning tools and that you were 100% confident that enforcement officers are using all of the tools available to them. And after having done jurisdictional scan, there's a few things happening in Canada where they've seen, based on the data, they've seen improvements in payments being made and some public reporting and the property tax approach. And so I'm wondering, in your opinion, are there enough tools available to the enforcement officers?
So I can tell you that it's on my legislative work plan that we're going to be reviewing the Maintenance Enforcement Act because there are significant tools available under the Act currently, but we could always have more, right? And we need the appropriate legislative authority to take that action. Now, a number of the jurisdictions across the country, and we are actively engaged with other jurisdictions about the work that they are doing. A number of jurisdictions have different tools that are available to them. They report differently about the success of those tools, and so we are currently engaging in a comprehensive jurisdictional review with the intention of, in the coming number of months, to look at replacing the Maintenance Enforcement Act. And so, would I like to have more tools available? Absolutely. But even if I am in this house next year with the new Maintenance Enforcement Act, if you asked me that question 6 months from the time the act comes in, I'm going to tell you that, hey, there's a new innovative way, being piloted in another jurisdiction. And so one of the things that we will likely look at is drafting the act in a way that makes it flexible to allow us to expand the scope of enforcement tools, but stay tuned.
Thank you very much.
Sunny?
Thank you, Chair. Thank you very much, ladies, for your presentation. In the 2020 Auditor General's report, she focused on your office and stated there was approximately 300 clients. Did you say you have 380 now, or did I understand that correctly?
So there are, in 2019-2020, we had 235 clients in the Public Trustee office who were solely clients of the Public Trustee. We had 16 clients in the Public Guardian office who were solely Public Guardian clients. We also had 49 clients who were clients of both the Public Trustee office and the Public Guardian office. So we can have individuals who are only under trusteeship. So a doctor has said, this person cannot make financial decisions, but they're capable of making personal care decisions. But we can also we can have somebody who is under the Public Guardian office who is capable of making financial decisions. But we do have a subset of clients who are under both trusteeship and guardianship. And that's where the office works collaboratively between the Public Trustee and the Public Guardian to manage all of those decisions for those particular clients.
Sunny?
Thank you, Chair. It's concerning your comment about people that leave the country. In your caseload, do you have very many of those that have left the country?
That would not be information that we track in our current system. We are often advised of things by individuals, but it is I'd have to go back to the office and see if we can get more specific information. But what I can tell you is that the number is not zero. We also see some individuals who move from jurisdiction to jurisdiction after they become uncomfortable with the enforcement in one jurisdiction. There is a process and a procedure that has to be undertaken to transfer enforcement from one province or territory to another. And so, there are individuals who you'll see in court orders sometimes. The court has the authority to do something called impute income to somebody. And that means, that's a kind of a fancy legal term, that means the court is going to say, maybe you're telling me that you're making $13,000 a year, but with your education and experience, you should be making 50. And you are making 13 because I believe that you do not want to pay child support. So I'm going to order you to pay child support. I'm going to impute your income at this threshold, and you will pay child support on that basis anyway. And so that is a tool that the court has and is used not infrequently. So, and again, I can't stress enough, PEI actually has the second highest rate of compliance with support orders through the maintenance enforcement program in the country. I'm talking about a small number of individuals that take action to evade having to pay support, both spousal and child support. But this is a small number of the files in our program. We have a very high compliance rate. That being said, it's these small number of clients that are the majority of the work for the enforcement officers and the Director of Maintenance Enforcement. And so...
Sunny?
This may be a tough question, but it just entered my mind. So you're talking there's around $10 million in arrears, and in comparison to your overall budget, could you give us an idea what that is, what that means in numbers? And also, you had indicated that there's people that don't go to court and get their order corrected if they change. Like, what percentage of that $10 million would that be? Like, is there, 40% that don't change their job description or change their wages for their support?
Unfortunately, that would be information that we don't currently track. One of the things that we are doing presently through the Maintenance Enforcement Office is working on new case management software. As you may, and I don't believe that you were here, Mr. Glant, for the last appearance, but the MEPS, the software, the case management software that we currently use in the maintenance enforcement program is an older software, and its reporting capabilities are not phenomenal. We are in process of replacing that with the same CompuTrust, same but different modules, CompuTrust platform that has been rolled out with the Public Trustee office. And so it is our hope that with the new system, we'll be able to engage in more data reporting. But I can say that from a operational perspective, the volume of arrears on a file doesn't necessarily change the enforcement action, because from the enforcement officer's perspective, their job is to take action to collect all arrears, right? So if there is any arrears on a file with maintenance enforcement, there is a federal interception in place. We are going to take your tax return money if you file your taxes, which sometimes means people don't file their taxes, right? We will contact your employer and put a payment order on your file, and we will take the money off your paycheck. So you don't get it, we do, and then we pay that for support. We prioritize enforcement action for the families that are not seeing any or all of the support in a month. And so the program doesn't care if you have $10,000 worth of arrears or 2,000. There are certain enforcement tools, however, that are subject to financial thresholds under the legislation. So we can suspend a passport through a federal act, so that you can't leave the country if you have child support arrears. But there's a threshold to that. We can only suspend your passport if you have $3,000 worth of arrears. And so the only time that we care about amounts in terms of enforcement action is determining which tools are legislatively available to us in terms of taking that enforcement action. So
Sunny?
And this will be my final question. So to that last remark, so if you are up to date and you decide to leave the country, you can't trace them. But if they're $3,000 in arrears, you can report that they can't leave.
yes.
Okay.
So, well, we can suspend their passport. Sometimes individuals have more than one passport because they hold dual citizenship. We only have authority over Canadian passports. And again, that's only in the circumstances where where the threshold for enforcement, which is set through a federal act, so will not come in terms of a new maintenance enforcement act through this province. But, if we have, we don't necessarily, the office wouldn't necessarily only suspend a passport in the event that we were concerned that somebody was going to flee the country. The office will suspend a passport if you meet the threshold for having the arrears, because people don't leave the country all the time because they're fleeing. Post-pandemic, people would leave the country to go on a vacation, and they would not be able to do that if they only had a Canadian passport, which was suspended because they did not pay their support arrears.
Great, thanks, Sunny. Gord?
So how many passports have been suspended in the last 12 months?
I would have to provide that information to the committee. I don't have that number with me.
Okay. Gord?
Yeah. Do you have interprovincial agreements with other provinces to suspend driver's licenses?
So there is something called the Interjurisdictional Support Act. And as we discussed last time, there's basically 3 different categories of support files with the program. We have what we call ISO in, so interjurisdictional support orders in, interjurisdictional support orders out, and then regular orders and agreements. Enforcement action is taken based on the location of the person who is paying support. And so if I am under a court order to pay support and my spouse and child live in PEI, but I live in Alberta, the enforcement of the support order happens in Alberta. And even if I had lived here when the order was issued, we would engage in something called an ISO process, where we would apply to have the order transferred to the Alberta program. And so my Alberta driver's license would be subject to enforcement actions taken through the Alberta program, because the maintenance enforcement program only engages in driver's license suspension for people where we are the enforcing jurisdiction. So if somebody was licensed in another province, generally it would be the case that they are resident of that other province and we are not the ones doing the enforcement. I say that with the caveat that enforcement decisions on what we call ISO out files, that's where the payor lives in the reciprocal jurisdiction, are made at the discretion of the other program. And so if you look at some of the legislation in the other jurisdictions, they may have different enforcement tools than we do. I mean, it's generally a standard fare that all of the programs across the country can suspend driver's licenses. But if the person is here and we are doing the enforcement and they have a driver's license, we have policies surrounding the suspension of driver's licenses, which are again subject to what we call an arrears threshold before we can actually engage in the suspension.
Gord?
Dollars you were talking about yeah. Okay. Roughly how many people are there right now who are entitled to maintenance payments who are not receiving the money to which they are entitled?
I'd have to bring back the specific numbers, but in terms of the files where there are arrears balances, it would be about 10 to 15% of the orders and agreements enrolled in the country. And you've heard me say this like 3 or 4 times right now because I'm really proud of it. We have the second highest success in order enrollment in the country.
Gord?
That's great. $10 million, when you were talking about that, can you put that in terms of people or families? Like how many are we talking about, like, would make up?
The last time that I ran the numbers, it was about 30 to 50 files of the 1,700 files in the program that make up the majority of that arrears balance.
Gord?
So I know you said that the maintenance is the same the same process with those, but do you obviously those are flagged and you're working on that. Can you tell us with the work that you've done, is it getting better? Is there more pressure being put on those 30 and 50 individuals?
So we have, over the past probably 2 years, seen a 200% increase in enforcement actions taken by the office.
Okay, Gord?
Fantastic.
I should also point out, because one of the things that, again, makes it a little complicated, it's not just interjurisdictional orders that can increase an arrears balance. So let's just say that my husband and I were to separate and we had a child. We could separate in 2017, but not go to court to get issues resolved on our divorce until 2020. It is possible for a court to do something called award retroactive arrears in support, right? So orders can come into existence with a significant arrears balance. And so we can see we can see 10,000, 60,000, 70,000 added to our ledger as soon as an order lands. And there's not been any action taken on that file because, one, it didn't exist before the court got involved, and two, before the court set the support, perhaps the parties weren't obligated to pay that support, right? And so as much as I understand that it can be a little frustrating, that number does not necessarily tell a story. The other thing that's unfortunate is often the files where we see these large arrears balances, these are the files where you would often find that we have maximized enforcement. We have, the Director of Maintenance Enforcement has brought this individual to court. A judge has sent this individual to jail for 7 days because they've not paid support. A judge has ordered them to make efforts to look for work. You know, we have a federal interception in place. Their passport is suspended. Their driver's license is suspended. We have a payment order in place at their known employer. right? And despite all of these actions, if that individual does not take steps to have a legal income source, despite some very strong comments by a judge and spending 7 days at the Provincial Correctional Center, enrollment in our program is not a guarantee of collection. And the fact that there are arrears balances on files is not at all an indication that there is not significant contact between the maintenance enforcement program and the defaulting payor.
Gord?
And that's so interesting that I know you're doing everything you can. So when you're talking about reviewing the legislation in the future, which is great, I'm sure it always happens, are you looking specifically at strengthening? I don't know what else you could do to strengthen that portion of this. So is that what are your top two or three areas that you're looking at in the new or looking at bringing legislation forward?
Well, so first, the Maintenance Enforcement Act in PEI is quite a dated act. The language in the act is a little bit challenging. There are, for example, provisions in the act that are not necessarily clear as to who can withdraw an order from the maintenance enforcement program. One of the priorities will be to ensure that the only person who can withdraw an order once it's filed is the person who is receiving support. Because if we have fundamental concerns always about circumstances where there may be power imbalances in relationships. And so, we are obligated under the legislation and through our policy to withdraw support orders where the parties agree. We want to change that so that only the person who is receiving the support is able to withdraw it. We want to also expand the authority of the director outside of a default hearing to take particular actions in relation to enforcing a file. We have significant authority under the current legislation to make information demands in relation to trying to locate somebody. So we can contact basically any public body in the province and ask if they have any information about the location of an individual. We are looking quite closely at Nova Scotia's Maintenance Enforcement Act because their tool belt is wider, and we want to empower both the enforcement officers and the director of maintenance enforcement to take more significant action. My biggest interest presently is setting up a mechanism whereby we can authorize the impounding of vehicles where people have not paid their enforcement, because we watched with interest the increase in payment of parking tickets to the city police when they started impounding vehicles. And so things like that, we just want to add incentives that speak to people about taking appropriate action under their orders.
Gord?
I'll wait till after, but thanks for the answer.
Okay. I'm just going to ask a few questions specific to the Office of the Public Trustee and the Public Guardian. And the Guardian. Can you describe the difference between the office and then you said that there was crossover, so a client could be a member of both, and can you just kind of explain that a little bit as well?
For sure. So the Office of the Public Trustee, the easiest way to think about it is the trustee deals with money, and the guardian deals with what we call personal care decisions. So where you live, healthcare decisions, like socialization decisions, things like that. And the public guardian has, if somebody is only under guardianship, the public guardian does not at all deal with money. And so the trustee deals with money. And even when we have a client who is under both the public guardian and the public trustee, so in terms of the structure of the office, we have the manager in the office is the public guardian, official guardian, and public trustee. She is empowered under both the provisions in the Mental Health Act and the Public Trustee Act. So Jessie can make decisions for both clients about finances and about if they're under both offices. But we also have a deputy public guardian, Deborah MacDonald, and a deputy public trustee, Chantel Fisher. Chantel makes decisions on behalf of the public trustee about money. Deborah can only make decisions about clients under guardianship. So we make decisions surrounding housing and medical care for those clients. Now, one of the things that I will point out that sometimes is challenging is we are not a provider of those services. We don't provide housing to a client of the public guardian, but we work with the client and their care team to determine appropriate housing for the client. And from time to time, for example, if the public guardian office determines that where somebody is living is putting them at risk, or that it is jeopardizing their health, the public guardian office would be empowered to terminate the tenancy for that individual, because we would make the decisions about housing and medical issues. So the public guardian would be, for particular individuals, consenting to particular treatments. And so the public trustee could not do that. If somebody is under the trustee but not the guardian, even if we get inquiries about decisions relating to personal care or medical issues, we would not have the authority to make those decisions. Those inquiries may result in us engaging in an inquiry to determine whether or not it may in fact be appropriate for the office to bring an application to the court to have the person brought under guardianship, but without that court order, we have no authority to make those decisions. And that's a key difference between the office as well. So the public guardian only gets involved under the current legislation if a court orders the public guardian to be involved. Sometimes we bring those applications, but it is, you will have heard me previously refer to the public guardian and public trustee office as an office of last resort. We are very aware that the authority that is granted to our office by a court order or through the trusteeship process is significant. Like, it is a significant intrusion on somebody's personal autonomy that they are no longer able to make these decisions. And in every case where we get a referral for either office, we engage in significant discussion with the care providers or the family about whether or not there's a family member or a trusted friend who knows that individual, who is more properly positioned to take on that role. And so the public guardian only gets involved if there's an order of the court. The public trustee gets involved if the court orders that the public trustee take trusteeship, but also under the legislation, if two separate doctors sign forms under the legislation to say that someone is incapable of managing their financial affairs, at law, we are then the trustee for that person, unless, because with the law there's always an unless, right? Unless there is something called an enduring power of attorney that somebody has signed with somebody else prior to our being involved.
And so you've kind of gone where I think I'm most concerned about. So estate planning is something that's crucial, especially when somebody gets to like that age in which, you know, they could have medical issues, that they can become incapacitated and they can't make decisions on their own. And so is there a high number that fall within the public office of the public trustee that, if possibly because the estate plan was not completed and maybe one loved one passed away and the directions or the family members were not identified within a will, within directions or anything like that, and how do you interact with the family then? Because obviously if a loved one that was given primary care passes away and you have somebody who is incapacitated in a hospital or what have you, then yes, you would get those doctor's notes. But does the public trustee work with the family that is left after the primary caregiver is gone in order to figure out that primary care?
So I'm sorry, I'm not 100% following your question. I want to make sure Are you talking about in circumstances where we are trustee?
So I'm talking about in circumstances where there is a life event where, so let's take a couple. Somebody is in care, and they do have a loved one that's the primary care, the wife or the husband or whatever, and they're giving primary care to that person. That primary caregiver passes away.
Yep.
And then the person who they were caring for is left behind, possibly with no directives, like no will or, estate planning that had been completed to say who that care would be passed on to. And then you said if you get 2 letters from a doctor, from 2 different doctors that state that they are not able to care for themselves, that would flag the public trustee to get involved. Do you then work with the family to find out, to figure out how that care can proceed without the public trustee being involved?
So in the same way, so as soon as 2 doctors sign those certificates, we are trustee at law. We have no ability to, there's no delay. Like the way the legislation is drafted, as soon as we are notified of those certificates, we are trustee and we take immediate action in relation to their financial interests. Now, remember, in your example, we would not be making necessarily personal care decisions for that person. Our only involvement with that person, unless there is a subsequent order relating to guardianship, would be in relation to the financial management of that person's, that person's what we refer to our clients as having estates, which is a little bit confusing because sometimes people hear the word estate and it also refers to after they pass away. If we have a client, when they come under the care of our office, in the same way as I discussed with the public guardian office, we would consult with the family members, one, to determine what the person's wishes may be in relation to their finances. Ultimately, we are the decision maker, and so the public trustee would have the final decision on any financial matter relating to that individual. If that individual passes away, if they have a will, that process, as soon as that person dies, if they die with a will, our involvement ceases. Because as trustee, we are trustee over their decisions while they are alive. And so if they have a will, that will would generally set out an executor and things like that. We would then complete kind of the financial processes in relation to that person, and we would contact the person who was the executor for the estate and make arrangements for them to come in, and we would transfer any trust money that we had in trust for that individual or any assets to that person because they are the executor for the estate. If we have an individual who is a client who dies without a will, which is called dying intestate, we would apply to the court to administer that estate. We would, because that person did not have a will, so I'm going to back up a bit. We would contact the family and ask if there is anybody who would be willing to act as administrator of the estate, and hopefully one of the family members would take that on. If they do not, we then limited to clients who die intestate without a family member who can administer the estate. We would then administer the estate and contact all of the known beneficiaries of the estate and go through the probate process. And so, again, ultimately, the decisions for that individual as the legal substitute decision maker are made by the public trustee. But as we do with when we have a client, we take steps to try and determine what the client's best interests are and what the client's wishes may have been, right? Subject to the fact that generally people are under our office because there are limitations that may mean that their wishes may not necessarily coincide with their best interests.
Okay. So I understand the whole difference now between guardianship and public trustee. I guess in my example, where I was going is if the loved one passes away, so the primary caregiver passes away without access to a person's bank accounts, financial information, like, so say I'm a daughter and that information was not passed on to me. I guess what I'm trying to get at is, at what point, because we want to keep people with their loved ones, and if somebody's, capable of making financial decisions for their father, for their mother, or whomever, I guess I'm still caught up, on that on the doctor's notes, and as soon as you receive 2 doctor's notes to say that they're not able to care for themselves, is there discussion with the person's family to identify if there is somebody that is able to do that? And do you help with that process so that they're not within the Office of the Public Trustee?
So currently, it is always the objective of the office that we are not involved with somebody. It is always our preference that there be a trusted friend or a family member who would be able to take that on. One of the things that we have identified through the operation of the office is, particularly in relation to, and in fact, in relation to both pieces of legislation, with the Public Trustee Office, we, at law, are involved as soon as those certificates hit. When we take on a client, we contact all of the family members. If we identify that there is a family member who is appropriate, we would be speaking to that family member about the fact that they could make an application to the court to have trusteeship transferred to them.
Okay, thank you.
Our involvement can also, there may be discussions with the family and with the physicians, because sometimes the doctors will sign certificates because the person is not capable of managing their own affairs, but the doctor, for whatever reason, may not know about the availability of the other family member to support that person in making those decisions.
Yeah.
And so at any stage, a doctor can actually cancel the certificates. And so our office engages in regular consultation with both the care providers and family. Now, I will say, from time to time, our office determines that it is not appropriate, that the family member is not an appropriate person to make these decisions. I'll point out that a number of our files with both guardianship and trusteeship are actually referred to us through adult protection. And so adult protection gets involved because there's concerns in relation to potential abuse and treatment by family members. And so our office becomes involved by an application to the court or through the doctor's certificates, because there is not an appropriate person in the family to make these decisions on behalf of that individual.
Okay, thank you for that. So I'm going to go back because you had talked about all of the recommendations. So for the public trustee, public guardian, and maintenance enforcement, and you had said that you will be 100% compliant, which I thank you for, because that is overall what we're striving to assist in getting that 100 compliancy actually realized. But what date, you didn't give us a time frame in which you would be 100% compliant by?
So we are 100% compliant now.
Now, okay.
We report to the Auditor General annually on the
Yeah.
status of the implementation. That report is being provided to the Auditor General on November 6th.
Okay.
And so we have all of the recommendations fully implemented currently, but we will be reporting that to the Auditor General on November 6th
Okay, great.
with much excitement.
I
and
bet.
hullabaloo.
So when we were talking, I wasn't for the public guardian, so I just kind of reviewed that. There was 4, I think there was 4 recommendations in that one. All 3 of them seem to have a documentation issue.
Yep.
And there's several of us that are actually on the special committee for government record retention, and so when a decision is made about a client, that's creation of a government record, correct? Is that part of your schedule as for the records information management process, like the RIM strategy? Is that
Yes.
those records are part of those?
Yes.
And so, what percentage to compliancy, for training and all that, and you know, your schedules and all that are you at currently for the RIM strategy?
For the public guardian and public trustee office?
And yes, and maintenance enforcement would be part of that as well.
So for the public guardian and public trustee office, we were in the process of updating our record schedule. I believe it is being approved at a committee this afternoon. And we are engaging in ongoing review of the retention schedule for the maintenance enforcement program, and anticipate that updated schedule will be approved in the coming months. Some of particularly with the maintenance enforcement program, the records in the maintenance enforcement program are a little bit complicated because some of them are court records, which are separate from government records. And so we are in the process of working with the provincial archivist and our RIM coordinator on updating that because of the complex nature of the work that office does, insofar as there's a lot of court stuff in with the government records.
Okay.
But all of the staff have all of
Been
the
trained.
required training.
Okay, thank you for that.
No problem.
Does anybody else? I have a couple more questions, but I can go for another round if.
I do, but you keep going.
Do you have something that you'd like to add there, Gord?
It's not the same situation. I just have one. I just kind of, maybe I'll just go. It's just wondering how the situation with COVID has affected your programming or anything in your office in particular that you'd want to speak about.
So I think it's fair to say that COVID hit everybody in a very unexpected way, and we had to pivot and change how we did business. I can tell you quite proudly, because of the work of my staff, there was no interruption of service provided to the public trustee office and the public guardian office. And both offices, the PGPT office and the maintenance enforcement office, they continued to operate during the reduction in services during the initial stage of the pandemic. Basically the only thing that changed in terms of both offices is that we moved to a model where meetings had to happen first via phone. That was basically the only change. And then we were available by appointment only, just so that we could screen the individuals coming into the office. We were very well positioned in terms of being able to accommodate the change, because just by virtue of the work that the offices do. The maintenance enforcement office and the public trustee office and the public guardian office operate a lot in front of their computer. And much of the work of the public trustee and the public guardian office happens by phone or previously in-person meetings. And so we moved to virtual meetings where we had to. And then when the restrictions were lifted, we developed an operational plan that included the ability to have in-person meetings subject to physical distancing and sanitizing and things like that. The biggest change in the office with the public trustee office was that we moved more quickly than we had previously intended to EFTs. And so while we make the majority of financial decisions for the clients, we provide them what we refer to as a comfort budget. And so each month or week, depending on the client, we provide like spending money to the clients. Previously, we were doing that via paper check that they would then take and deposit into an account that they had access to. We moved to EFTs. And so we have seen not a reduction in contact with clients, but a reduction of in-person contact with clients. But 100%, so the maintenance enforcement program was, one thing within the maintenance enforcement program was impacted. So the court, through the pandemic, never closed, and I cannot stress that enough. The court was open the entire time, but they did move to an urgent, essential, and emergency model only. And so for the period of about March until I believe it was May, we did not have default hearings where we brought defaulting payors in front of a judge and asked them to take certain steps. And so that was really the only reduction. But we had a stack of files prepared for when the court resumed its regular level of service. And I'm not gonna lie to you, the September docket was a little bonkers because we were catching up on some stuff. But no change in terms of the service provided to clients.
Gord?
So you're all caught up there, everything is, yeah, that's great, that's fantastic. I just want to, like, my final question would be I think it's CompuTrust, I think that's what it was called, it's going to be done by the 2020. Just wanted to make sure that that's still online, or not, it's not online yet, but it's coming. I know it's going to be done in the winter.
Awesome question, because it lets me tell you that we're ahead of schedule. CompuTrust in the Public Trustee office rolled out in August. And so we are in process of doing the data entry. So you may recall the last time I said we're going to roll out the software and then we have to do the data entry into the program. It rolled out in August and oh boy, it's beautiful. Like, it is life-changing in terms of efficiency within the office and the built-in controls. In terms of the functioning of the program, we are now focused on the development of the module for the maintenance enforcement program. And I hope we were a little bit delayed in terms of the maintenance enforcement module, only because during the shutdown for the pandemic, our contractor was also impacted, and so they had their time was impacted and we prioritized the completion of the public trustee module. But I anticipate probably by the end of March, hopefully December, we will roll out the module for the maintenance enforcement program. And even more than the change in the public trustee office, it will be life-changing for the maintenance enforcement program. Like, it's beautiful. Yeah.
Gord?
Makes me want to try it out, but I guess we can't. But anyway, thank you very much. Yeah.
All right, Carla?
So one of the recommendations, kind of loosely worded from 2016, was that the maintenance enforcement office should obtain documented consent from beneficiaries before arrears balances are reduced and no longer enforced. And so, correct me if I'm wrong, but like if someone owes a crazy amount of money to maintenance enforcement, the office can reduce it if the beneficiary agrees. The auditor found that the office was reducing amounts without documentation and that they got the okay from the beneficiary. I'm trying to understand that. Like, what is the point of that? Why would the office do that? What's the process?
Okay, so and if you would like, you could refer to our policy manual, which has a comprehensive policy on arrears collection and overpayments. So there are circumstances from time to time where individuals either wish to withdraw from maintenance enforcement, and there are arrears on our ledger. And so in order for us to withdraw the file from the program, the policy manual sets out documentation and processes that are required. So, and I apologize because I've been here a couple of times and I can't remember at which appearance we talked about it. But so from time to time, we will have something called a global support order. So if Claire has 3 kids, and I have a child support order, sometimes the judge will issue an interim support order that says Claire's ex-spouse is to pay support for each of the 3 kids, which totals $700 a month. I'm making this number up. $700 a month. But maybe Claire's oldest has turned 18 and has decided not to go to a post-secondary education institute, which from our perspective and from the order's perspective means that the support for that oldest child is no longer, it terminates, right? Because the order says support continues until they're 18 or they continue in a post-secondary education institute. Previously, we did not have a process wherein the program could do something called a step down. So we couldn't look at that support order and say, well, that $700 was the math of the support obligation for each of those kids, and we'll just subtract the support amount. So we would have files, and we continue to have files, where people the support terminates, and we hear from neither the person receiving the support or the person paying the support. And so there may be on the file where support has terminated arrears over the course of the program that we have been trying to collect. We would be taking enforcement action to try and collect those arrears, but under the policy, we now try to contact both parties and get them to confirm that they actually want us to continue enforcing those arrears, right? Sometimes we'll hear from both people, that they don't want us to continue enforcing support, that they're good, right? And so at that stage, we would close our file and we would no longer continue enforcing the arrears. One of the things that sometimes people, and we do what we can, and you'll notice this language on a lot of our communications with users of the program, the maintenance enforcement program has some discretion under the legislation to make decisions about enforcement. We also can withdraw an order from the program, but withdrawing the order from the program, even if there's arrears on the file, isn't a commentary on your legal obligation to pay those arrears, right? We can't just get rid of arrears. Arrears coming out of our program doesn't mean that at law, my spouse may not owe them to me. It just means that we are not enforcing it. So we now have a comprehensive process to document the discussion, and the policy sets out kind of timelines to give people the opportunity to respond and things like that. So we don't, and where we get a request to withdraw a file from the program and there are arrears, there's a process for us to document that both parties are approving, because one of the challenges that can arise is, as a neutral order-based program, we're not a tribunal. We don't hear evidence from people and then make decisions about what happened. So if I withdraw my order from the maintenance enforcement program and there's $5,000 worth of arrears at the time that I withdraw, and 2 years later I come back and I say, not only has he not paid me the support for the past 2 years, but he hasn't paid anything against that $5,000, we may not be able to enforce those arrears, because we can't, if there's dispute between the parties about, well, I paid it and that type of stuff, we can't make decisions about whether or not that money was actually paid, and we have to refer those people to the court. And so we provide all of that information to both parties and document that information in the file to ensure that people understand the ramification of removing files from our program or declining to have us continue to enforce arrears.
Carla?
I just find it sad that some of these cases are terminated. It may be from both perspectives, they've deemed it okay to close, but the fact is that these children have aged out and never received the support that they needed to be healthy in the first place. And so they might have wanted to go to a post-secondary education, but their life just didn't allow them to take that path. So I find that a little bit frustrating in terms of responsibility. So I'm a systems thinker, and so I don't, it's not the individuals who work within the system, it's set up, the way their work is set up and how they do. And so a couple of questions around that. So maintenance enforcement, despite sounding like, we enforce these payments, that's not the case. So who ultimately, is it the courts that are ultimately responsible for ensuring, or it doesn't seem like anyone's really responsible for ensuring these payments get made? Who's responsible?
So I'm going to respectfully disagree with you. We are responsible for enforcing. It's just that enforcement is not a guarantee of collection. And so we, every day, take significant action to enforce. It's just in the same way that, ultimately some people choose to disregard the existence of consequences. I mean, you can see that throughout the court system, right? I mean, if I have a panic attack if I see lights behind me on the bridge and it's a police officer and I'm not doing anything wrong, right? Huge incentive for me to not engage in criminal behavior, right? Because I don't want to be in trouble. It's not my bailiwick. I would pay my support if I was ordered to do so, because A court has ordered me to do so. But despite the availability of significant enforcement tools up to and including jail, ultimately it is the decision of the person who is obligated to pay support. And those individuals who are not paying support, the other thing to recognize is the fact that a file is involved with maintenance enforcement does not mean that that file is not also involved with court. We have individuals who make applications to have their child support varied or their spousal support varied, and ultimately those decisions land with the court. But, when we're talking about circumstances, which again, I cannot stress enough, are not the majority of the files. We are talking about a very small number of individuals who do not comply with support orders. But, at a certain point, people have their own autonomy, and I don't know what more we can do than send people to jail, right? I mean, it's significant. You can go to jail for not paying your support. Jail. So ultimately, people involved with support orders can bring their matter back to court and ask for the court to intervene according to the court's authority. But we do enforce orders. We do it with regularity, and we do it over the objections of the people who do not want to pay and do not enjoy that we will garnish money from their bank account, and do not enjoy that I will contact your employer and tell them that you're not paying your support and take the money off your paycheck, right? Maintenance enforcement, for some people, is uncomfortable. And I am neutral. So we don't concern ourselves with whether or not somebody is uncomfortable or disagrees with the action that we take. We concern ourselves with what the order says and what the agreement says and what we can do to maximize the collection and disbursement of support for island families.
Carla?
Thank you for that. So I guess in trying to understand kind of barriers and gaps, I don't have data sitting in front of me, but I can imagine what the data says about who's affected by these, speaking maintenance enforcement still. So, we look at barriers and gaps that systems have that work against the very people that they're supposed to serve. And again, that's why I go back to it's not the individuals who work within these systems, it's our legislation and it's our process and it's what we go by. And so I'm trying to understand from that perspective what the barriers and gaps are for, and we kind of already addressed it through tools, and maybe you feel like you've already answered this question. I'm just really trying to wrap my head around it. That what are those gaps and barriers in the legislation itself that is contributing to, to people not getting what they deserve in terms, speaking from even a advocating for children perspective. I'm just trying to understand what it is, what are the barriers and gaps that are in our legislation that's stopping people from getting what's owed to them, I guess, if that's...
So again, the complicated nature of that question is hinged upon the fact that the maintenance enforcement program is not a social program. We are, basically, fundamentally, we are a collection agency. And so in terms of the barriers and gaps that may impact people's ability to pay or see support collected, those are with respect, social issues that fall outside of the maintenance enforcement program. What I can tell you is that my division has within it a free service that is provided to everyone called the Child Support Guidelines Office. And so one of the barriers to the ability of parties to even get a court order in relation to support is that's an access to justice issue. And so the Department of Justice and Public Safety provides an amazing service called the Child Support Guidelines Office, where we have child support guidelines officers in both Charlottetown and Summerside who assist parties who want to make applications to the court for child support or to vary child support. And so I have amazing staff who work with members of the public to help them navigate the complexity of the court system. And it's an information and assistance program. We don't provide legal advice, but we do assist them with understanding the drafting of court documents. And so if for example, somebody has challenges with the support order that they have in the maintenance enforcement program, we have a very collaborative relationship between both the Child Support Guidelines Office and the Maintenance Enforcement Program. And so when we get inquiries about support issues, we have a service that we can refer people to that will not only help them understand the court process, but assist them with getting to court and getting in front of a judge to get an order, to get support that assists their children and their family. And so in terms of the kind of confines of the collection agency, we do everything that we can. Like I said earlier, we would previously have had a number of individuals that say, well, I can't afford to do my taxes. Like, I would do this, but I can't afford to do it. Okay, we found a free service that will help you. And there he is. Walk over there, give him all of your information, and that tax return will be filed within 30 minutes. And oh, by the way, I already put a federal interception on your file, so that money, you're not going to see it, right? And as soon as they file that tax return, they're also potentially eligible for benefits that assist them outside of their child support, right? One of the reasons why, and I can't speak for the CRA, but one of the reasons why this volunteer income tax clinic exists is to assist people with completing tax returns so that they can avail of federal benefits and resources and provincial benefits and resources that they may not otherwise have access to. And so I fully understand that it is challenging, and I get what you're saying, but in terms of our role as a neutral service and as a collection agency, that, by the way, is a free service provided to Islanders. Anyone who has a support order or agreement, whether or not it is currently enrolled in our program, can come down to the Family Law Center and engage with our staff, who will take significant steps to enforce their orders. So, and I cannot stress enough, we have the second highest compliance rate in the country for people who pay support orders, right? And these are people who are enrolled in our program, and we would never hear from them because they pay their support every month. And so we contact them once a year to make sure that their contact information is correct. And they likely get that email and say, who is Charmaine McGuinness? Oh, right, she's my enforcement officer. And I never hear from her because I pay my support, right? This is a very limited number of challenging individuals, and these challenges are across the country. But they are the exception and not the norm.
Carla?
Thank you for that. And it's just, when you hear numbers that big, you can't help but think that, the first question that I asked about the $10.4 million, when you hear that number, right, to me, it makes my brain think that it is a lot more common. I was going to pick up on something that you said. Maintenance enforcement not being a social program, I guess that's kind of the biggest thing I'm having a hard time wrapping my head around, because personally, I know it's not under the law, but just personally, I do see it as a huge social issue, right? What's leading to it. And I appreciate your comment about the access to justice piece. We've been meeting with various individuals and community groups, and that is the hugest issue that has been recurring as of late, is this access to justice. So I'll leave that there for now. Thank you.
Okay, I just have a couple of wrap-up questions. Oh, Corey, go ahead.
Claire, you had mentioned that 7 staff is enough to manage the 1,700 files. Just because at the start you had said, like, we have 7 staff and 1,700 files, as if it wasn't enough.
No, I meant, because sometimes, with respect, you look at the Auditor General's recommendations, and it's easy to not connect that to the staff that are doing the work every day. I have 7 staff in that office who, I'm not gonna lie to you, we have regular staff meetings, and the Auditor General's report comes up at every staff meeting, right? Like, when I sit here, and I understand, I'm hugely passionate about the work that my office does. I think that they are amazing. I think that they are dedicated. I am probably the least passionate person in my office in terms of the service that we provide. Like, I have a staff member who I happened to be at the office early, and she came in at 7:30, like a full hour before she was supposed to be at work, and she said, okay, I had this idea last night about the report that we did and how I think we can tweak it a little bit to get better information, right? So, I mean, Claire sits here and she's like captain cheerleader for her staff. There is a reason. And I really want to connect the fact that, you know, I've heard from time to time that there's concern that there's not action on Auditor General's recommendations. I'm not going to lie to you. When I sat down with the managers of these sections and we went through and said complete, like, one of them said to me, what are we supposed to do now? Like, we've spent 3 years trying to get this done, like, you know, so I don't know that you will find, and I'm sure you would because there's lots of dedicated people, but, you know, we have, and I cannot stress enough, the work done by both the Public Guardian and Public Trustee Office and the Maintenance Enforcement Office is challenging work. We are dealing with high conflict individuals. Like, you would have seen in the Guardian, there were criminal charges arising out of the conduct of one of the defaulting payors at the Family Law Center. Like, he was sentenced to jail because of his conduct at the Family Law Center with my staff, right? The police had to come and remove him from the building. And so, you know, this is challenging work. I had a sheriff at the Public Trustee Office a couple of days ago because there's an individual who is under the care of our office who has significant challenges, and he does not agree with the involvement of our office, despite the fact that there's a multitude of information and a court order and doctors saying that this individual needs our help. I had a sheriff at the office because he was using not only language that my grandmother would not appreciate, he was also engaging in conduct that was not at all appropriate. And we have to have a sheriff at the office when this person comes. Mm-hmm. And so, do I think I have enough staff? Absolutely. May I consider, do I engage in ongoing operational reviews? And Ms. MacDonald will tell you, and the Director of Finance will tell you, Claire, they get calls when I think I need more staff, and they get multiple calls. And so we have done significant work over the past 3 years. The staffing complement in the Public Trustee Office and the Public Guardian Office doubled. We added 2 additional enforcement officers, one through a new position and one through reprofiling an additional position. And so that 7 number, that is an expansion over when the Auditor General's report was put in place. I'm also adding an additional finance-related position to both offices to assist because, as I said, our financial statement audit is hugely complex. We have complex financial processes in both offices. So I don't know if I get to come back if we're at 100%, guys, but if I did, we'd be at 8 staff in each office. So rest assured, if there are additional resources that are required, the department is committed to ensuring these offices are appropriately staffed. And in my respectful opinion, they are now.
Okay. Corey?
Okay, thank you, because at the start, it kind of sounded like these people are overwhelmed, and I understand that it would be I think it would be a stressful job, you know, dealing with all the individuals you would deal with.
And if I can just let you know, I can absolutely tell you that my staff have been overwhelmed. Particularly during audit time, you know, I'm not joking. There were 4 auditors in my office the last year when they were doing the audit. Prior to, and this year's audit was the cleanest process that we've ever had because we've implemented a number of changes. We've done a file reorganization. Next year, with a full year with the CompuTrust program, it'll be even easier. But absolutely, because I'll give you an example. During this year's audit, which happened in July because of the pandemic, we had 2 auditors at the office. We had a influx of new clients in the Public Trustee office. We got 13 new clients in 1 week. And each of those clients had about 10 years of back taxes that had to be done before we could immediately apply for the benefits to support them through the long-term care benefit. On top of that, we had the 300 clients that call every day. We were finalizing our annual report. We were finalizing the CompuTrust. CompuTrust was rolling out at the same time. We were moving to a completely new software package, and all of this was happening at the same time. So yes, there are times when absolutely my staff is overwhelmed. And will there be a party with physical distance and potential cake about the fact that we are at 100%? Absolutely, because this means that we can focus going forward on making positive changes to how we're doing things and supporting clients. So,
Corey?
Is there a high turnover rate among staff, like due to the stress that can be, or do you, is there, do you have reports of, I guess, staff, you know, needing support or like that are you know, stressed to the max, or maybe that perhaps that's not an issue, I don't.
So we, in the maintenance enforcement office, of the 7 staff, 2 are new because of new positions. We've had 1 staff person who is currently on a secondment to a different department, and all of the other staff have been there for many years. The Public Trustee office, we've had, in the past 3 years, there's been some turnover due to position changes and things like that. But we have like dedicated people who are committed to where they are. We also spend a great deal of time checking in on staff because of the nature of the work that we do. The division is currently working on offering something called compassion fatigue training. And I meet, I'd like to tell you it's weekly, but it's probably more accurately daily with the supervisors to make sure that any issues that arise come up. And particularly with the maintenance enforcement office, the policy allows for us to move files between enforcement officers, just because, you know, from time to time, when you're dealing with challenging individuals, we like to, you know, move the files between the more senior enforcement officers just to prevent burnout. So, you know, I don't know that it's realistic to think that anybody working anywhere is happy 100% of the time, particularly with the challenging work that they do. But I think that if you spoke to the staff in the office, it's a great team, and particularly the maintenance enforcement team. They're really behind, and they really agree with some of the changes that we've made in the office, and you know, to be honest, they love the policy manual. They love having something that they can refer to, that they can refer the public to help them understand what the kind of limitations on our role is, what the nature of the work is. And so, you know, I can tell you that I've often had to come out of my office and tell the Public Trustee office and the Public Guardian office to quiet down, that there will be no laughing at the Family Law Center, because it's a fun work environment. They love the work that they do. They love the clients that they have. And it's challenging, but it's really rewarding. We get to help people. We get to help families.
Corey?
You had mentioned some security issues. Is that an ongoing issue, or is it just like was that a one-off, or is it like, are you in a secure building? Do you have security?
We work in a secure building. We have like panic buttons and alarms. We also have access to the sheriff's office that we work collaboratively with. And so, you know, if there are issues, we also, through our panic system, have a direct line to the city police. The nature of the work done at the entirety of the Family Law Center, like I said at the beginning, children and money are 2 of the most high conflict matters that people deal with. And so we are very aware of the necessity of keeping our staff and the public safe.
Corey?
The Child Support Guidelines Office you had talked about quite extensively there, is that used more so for, is that used for both, like the payor and the,
Absolutely.
and I guess what's the
recipient?
The recipient, yeah. Is that used by both?
Yes.
Okay.
So we, The service provides and again, it's a neutral service. They're not representing either party, but they provide information and assistance with court documents to vary or establish child support. And so which party wants to request a variation of a support order? It could be either the person paying support or the person receiving it.
Corey?
So if the payor wanted to change the order and they use this service, is the other party notified that it will be?
Yes.
Okay.
I mean, again, subject to certain exceptions and complications with the law. Child support applications are applications that have to proceed what we would refer to as on notice. And so when somebody's making an application to go to court to change child support, before the court will hear the application, the court has to have something called proof of service on the other individual, which shows that the other person received notification of the application. Again, there's some caveats and corollaries, but effectively that is a requirement. The other person doesn't necessarily have to show up, but the court has to be satisfied that the person knew or ought to have known that the application was proceeding.
Corey?
I've had this mentioned to me a couple of times. Is it, if the payor changes employment, their income changes or whatnot, whose responsibility is it to track that or to, because I've had, I guess, the recipients, some tell me that they almost feel like the onus was put on them, that they had to let maintenance enforcement know when the payor changed employment or to track that. Is that?
So the parties to a support agreement are obligated at law to notify maintenance enforcement if they've had a change of address or a change of employment. If the program has challenges contacting people, like I think I referenced earlier, the director of maintenance enforcement under the Maintenance Enforcement Act has significant information demand powers. And so from time to time, it is absolutely the case that sometimes the recipient will know sooner than we do that somebody's had a change of employment. The program constantly tells recipients and payors, let us know if there's been any change. Because if we have a payment order in place against a person and that payment order is coming in with regularity, we would not know from the employer unless the payor notified us that there was a change in position, right? Now, like I said earlier, we are a neutral order-based program. So even if we are advised that the payor or the recipient have had a change in circumstance, that, subject to certain policy limitations, doesn't impact our enforcement activities. We do have a policy in the program called the Payor Compliance Plan. So from time to time, the program may be advised by somebody who's paying support that they've lost their job. This happened a couple of times during COVID because people lost employment, and we would be contacted by the payor to say, I am now unemployed and I'm on CERB, which we were not able to intercept. And so the payor would come and say, I was making $150,000 and now I have no job. And so the policy allows maintenance enforcement to enter into a written agreement with the payor, requiring the payor to provide certain information. This is not a circumstance where somebody can call us and say, I've lost my job, and then we do nothing else. If they provide an ROE, if they provide particular information, we will, through this policy, agree to not take enforcement action for the full amount if they pay whatever they're saying is now their salary. We give them 90 days to make an application to the court. They are advised arrears on the file continue to accrue. So if your support was ordered to be at $800 and you've provided us information that your employment per the child support guidelines tables would mean that you're to pay $500, that we would enforce. We would not take enforcement if they pay the $500, but the ledger is still accruing that additional $300 a month. So if we are militant about maintaining contact with the payor. What the individual who was arrested was concerned because we terminated a payer compliance plan, which he did not agree with because he did not take the appropriate action. But they get 90 days to go to court and make a variation application. And if the judge agrees with them, then the order sets aside the additional $300 in arrears. If the judge doesn't agree with them, we immediately recommence enforcement on the full arrears amount and would do the interception and the payment order for the full amount. But this just, so because we are neutral, we cannot prefer the information of the recipient over the information of the payor. And so that is the one kind of exception with the note, and I cannot stress enough, arrears continue to accumulate at the ordered amount. The maintenance enforcement director under the legislation has discretion in terms of the enforcement actions that are taken. And so we have actually seen, because of this payer compliance plan, more people who are going to court to get the order changed when they have these circumstances. Because previously, if we were not doing that, they would say, well, what's the point? You're going to take $800 and I can't afford to pay rent, so I'm just not going to go to court anyway. And so we've seen an increase in the number of people who are following through on variation applications because we, quite literally, the compliance plan allows us to communicate with the Child Support Guidelines Office and confirm that they actually showed up for the appointment and that they actually completed the application and for us to be notified of the court date. And so it has been a fairly effective policy, and a number of them have actually resulted in consent orders where both the recipient and the payor agree that there has in fact been a change of circumstance. So,
Corey?
Thank you, and I just want to thank you both again for coming in and implementing 100% of the AG's recommendations. It's very much appreciated.
Thank you, Corey. Any other questions? So I will extend the same congratulations on achieving 100%, and you've made a lot of good points. And I think in particular what this has highlighted for me is we have 3 offices that have now better processes in place that are in line with legislation. Based on the Auditor General coming in and spending countless hours as well with your staff. And I think what I guess kind of concerns me is the Auditor General's office is not big enough to go out to every single department and audit every single department. So I think really the recommendations that they make for each and every department should kind of be looked at across government to say, okay, well, what recommendations were made there? How can that impact us, even if it's not verbatim, but what practices can we put in place to alleviate stresses that would have been on your employees, to be honest, Claire? Like, I'm sure that there was probably things throughout the years that were probably pinpointed as, we can't do this because we don't have this, 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 and this. And it's, I think, important that senior management listens to those recommendations from within the departments, so that if you know you're not compliant, you can't do your job because you don't have the tools to do your job, there is a requirement from senior management to ensure that the tools are in place. And so I'm going to take you off the hot seat for a little while, probably for the rest of the time. I'm going to say, just ask you, Karen, as Deputy Minister, and realizing the Auditor General has now gone through 3 significant offices, under your area. What policies have you implemented now to ensure that departments have the support that they're going to need going forward in order to stay compliant with legislation? Because this has been going since 2015, and it's taken us 4 years to get, starting with maintenance enforcement into compliance. But at what point in time do they start lagging behind again because they don't have the software, they don't have the policy manual, they don't have certain things in place in order for them to be able to do their job? And I'd love to hear, what, I guess it would be audit processes within your own department to ensure that that the different offices are being supported.
So what I would say is that the department certainly, we take the approach of continuous improvement. So that is an area of interest for me, to ensure that we are always looking at the services that we're delivering to ensure that the best service, but also looking at the ways that the work is done. So whether it's looking at technology or policy or documentation, and I don't think that there's any doubt that the department generally watched what happened in relation to Auditor General's recommendations, and I think understood that we needed to think about how did those things apply in other parts of the organization. We do a lot of different things in justice and public safety. So aside from the work that Claire and her staff are doing, we have corrections, we have public safety, we have the Crown's Office Legal Aid. So we're doing a real range of things, but we are talking regularly, and we do have we do tracking around the sort of commitments that need to be followed through on, and sort of those regular updates. So that's part of the conversation with the senior management team, with the directors group. And I would say that over the last number of years, there's been an improvement in the capacity around things like policy development. I know that from a technology perspective, we've done a lot of work across the department, and I would say in government generally, on improving technology and ensuring that systems can work together to gather information, report, those kinds of things. So those are things that we're paying attention to. How do we ensure that our staff right across the division have the tools that they need to do the work? And how do we ensure that there is that continuous improvement? So rather than asking the question or taking the position, I guess, that, well, we're doing it this way because this is how we've always done it. Certainly my interest is, what does the evidence say about how we should be delivering this service? What's happening in other parts of the country? What's happening in Atlantic Canada, probably in particular? And again, what does the evidence say about how we should be delivering services? And so there certainly is an expectation that folks are considering that as they're doing annual work plans, doing strategic planning, thinking about how their service needs to evolve.
Okay, thank you. Yes.
So you've made a couple of comments about the Auditor General finding that we weren't in compliance with law and legislation. And I just wanted to clarify that nothing within the Auditor General's reports indicates that we were not complying with either the Maintenance Enforcement Act or the Public Trustee Act. The Auditor General's recommendations related to processes and accounting processes for how we were documenting significant decisions and the steps that we were engaging on the more of the policy side of the functioning of the office. There has never been, nor with respect, do I think there would be a finding that we were acting outside of our legislative authority.
Well, actually, though, Claire, I would just point to an example that's in the Auditor General's report in which a deceased client's yearly fees were being taken out for 13 years, and the department never identified that that should not happen, which would be, I would think, in contravention to the legislation, because if the person has passed away in 2004 and we're still collecting fees in 2016 from that client, I don't see how that would be in compliance with with legislation. So I understand that it's policy-driven things that meant that the administrative work couldn't be completed. But when administrative work can't be completed, it is difficult to actually be in compliance with legislation, because taking fees from a deceased client I don't think any of us could agree that that is in compliance with the legislation.
Right, but the Auditor General makes recommendations on the basis of policies and practice.
Right, to make sure that things that have happened that are not in compliance don't happen again, because if you don't have proper policies in place, people fall through the cracks. And for instance, that one example in the AG report is a clear example of somebody falling through the cracks because nobody thought to update his file or her file in 13 years. So that just goes to show the Auditor General makes recommendations that is improvements to policy to ensure that certain things don't happen that are not in compliance with legislation. So I understand the difference, and it's a very technical difference, but the Auditor General, that's what they take their findings and they provide recommendations. They're not just recommending it because it's a good practice. It's recommending it because they're comparing it to the legislation, and if their findings is not in compliance, how do you fix that? And they're providing recommendations how to fix that.
Right.
So I think we agree in principle. So I don't have any further questions. If no other further questions from the committee, I would like to thank you very much for coming in. I guess next year with the Auditor General report in March, we will also see the update again from the Office of the Public Trustee and then the Office of the Guardian to follow their schedule. But I do hope that your employees get to celebrate 100% compliance, because that's a big step and that's something that you should be proud of for sure. And, and we're happy to hear that as well, because that's something that, this committee wants to see everybody strive for. So we'll celebrate when you get there as well. So thank you very much, and I appreciate you joining us. And we'll just pause for a second and then continue with our agenda. All right, so we'll resume. We're on item number 4, which is review of correspondence. And there has been some letters received. Ryan, do you mind taking us through those? I know some have gone out, but just recently, as of yesterday afternoon even, I believe. Am I right in that?
Oh, I can go through it for sure.
That'd be great.
There's a memo in front of you. In the memo, the first letter is one that was received just yesterday from the Deputy Minister of Transportation, Infrastructure and Energy, responding to the committee's request that he provide the follow-up information on the Access PEI audit that the committee had requested last fall. So that letter is the first one in your package. And then the other 3 letters in the package are letters that the committee has sent, one of which was to Transportation to request that information within a 2-week time frame. Another letter to the Deputy Minister of Environment requesting follow-up information on the management of contaminated sites audit, also with a 2-week deadline, which will come to the end of on Thursday, the 22nd. And then the third letter is to the CEO of Tourism PEI, seeking an update on whether all recommendations on the 2019 audit of capital asset plan for provincial parks are now implemented as they're scheduled to be by fall 2020.
Great. Thank you, Ryan. So the letter that we received from Darren Chason would be in direct, I guess, in response to the letter that we sent out as to where they are with the recommendations. And so we'll need, I think we'll need a decision as to if we take further action with this update, or do we schedule another time to do a further follow-up. In it, I do know that they're looking at having all agreements signed with the clients by 2021, 2022. The Highway Safety Division, which was the one that they had committed to, will be November of 2020. And then I think that they also identify that for the software, the last recommendation, the procedures for adding and removing users in the single window access technology in driver vehicles. I don't have that right in front of me, but they've documented their procedures. There's one, though, that they say that they couldn't do. I guess it's recommendation 2.45. The conclusion was the system was not, could not produce sequential transaction numbers. However, it was confirmed the transactions cannot be deleted. A process has been created to ensure the completeness of the data in both systems. So I guess we'll need to make a decision on what we do with this particular audit. And do we just follow up at a further time? Go ahead, Sid.
Thank you, Chair. Yeah, I move that we follow up with them by letter at the end of the first quarter of 2021.
Okay, any discussion on that motion? All in favor? Yep, thank you. So that's great. And then once we have the responses from the other two parties, we can discuss further. Okay, and then review of scheduling. Ryan, do you mind taking us through that? I don't have it right in front of me.
Certainly. The next meeting is next Tuesday, the 27th. The Department of Social Development and Housing will be present to discuss implementation of the 2017 Seniors Housing Program audit recommendations. Also at that meeting, the committee will be briefed by finance officials on the fiscal and economic updates. Then the next meeting after that would be November 10th, which is the training on the public accounts with the Canadian Audit and Accountability Foundation. I should mention too, as discussed last time the committee talked about that training, it will be led by the president of the CAAF, but they had made some options available for former elected officials to participate as well, and the committee was open to that. And so Sean Murphy, former member of the Federal Public Accounts Committee, will attend and participate as well.
Okay, thank you, Ryan. Appreciate that. And also to note that it is a public meeting and open to other members of the Legislative Assembly. So if there's anyone within the different caucuses that would like that training on public accounts, it is open for anybody to attend if you want to share that as well. So that is scheduling. Any questions on that? Any questions, concerns? No?
Excuse me, Chair.
So, Sunny?
Training?
November 10th.
November 10th, thank you.
Thanks. And then for item number 6 is new business. Does anybody have any new business or any items that you'd like to discuss with the committee? Okay. I will ask for a motion to adjourn. Good. Thank you very much, everyone. Have a great day.